ASIC set a high bar for itself to establish the liability to the extent that he had serious doubt whether an actual breach by a corporation is a necessary requirement for breach of Section 181 to the extent there were 45 individuals or 27 individuals or couples upon whom ASIC final dependent Mr. and Mrs. Casamites incorporated procuring to contribute more than the monetary authorities would some way or another be set up to enhance the circumstances in 5 years or more. System was depicted by one onlooker as double gearing and incorporated the budgetary masters by gaining against the security of their homes. Also, also securing an age credit and using the benefits from advances to place assets into document stores, developing a cash spare and paying Strom's costs. Mr. and Mrs. Casimites introduced that Section 180 in 1 doesn't have any kind of effect where the boss are the sole shareholders of solvent company. ASIC moreover contended that in causing or enabling advice to be given in a way which influenced Storm to disavow the Corporation Act, Mr. and Mrs. Casamitis introduced Storm to an anticipated threat of harm, most important than that to which a sensible head, acting with the required level of care and diligence, would enable Storm to be revealed. The straightforward reality is that a boss shares in lead that passes on which it an anticipated risk of harm to the interest of the association won't, won't, won't generally suggest that he has failed to enhance a sensible level of care and determination in the arrival of his commitments. Requirement whether a boss has drilled a sensible level of care and investiness must be answered by modifying the anticipated peril of evil against the potential points of interest that could sensibly have been depended upon to gather to the association from the lead being alluded to. So, finally, according to the Edelman J, moreover observed that the anticipated threat of insidiousness to the endeavor which tumbles to be considered in Section 181 isn't limited to physical harm. It fuses evil to each one of the interests of the association, including its reputation, interest, and the risk of introduction to the section from overstep of the law. Thank you. This was the introduction part, and the further part will be done by the next group member, that is Mahesh Shrestha, and the topic would be duties and responsibility. Please, thank you.
Hi, this is Mahesh Shrestha, and I will be dealing with the duties and responsibilities breached in this case. Uh, the duties and the obligations under the Section 180 requires in the executives of the officer to adjust in the risk that it anticipates and that would hurt in the organization. This will frustrate the development of the organization and is influenced by the size of the risk and the probability with which it happened. This would happen by a specific course in an activity or a non-activity alongside the weight of the cost. The damage alludes to any of the enthusiasm of the organization. The expressed area would not require in the verification of any genuine or a point of view misfortune to the organization. The care that ought to have been practiced relies on the conditions of each case and the likewise on the executives and the officer position and furthermore duties they have breached. The ASIC started procedure in the Federal Court of Australia against Mr. and Mrs. Casimitis, affirming that they submitted a solitary breach of their obligation of care and diligence under Section 180. In this case, ASIC versus Casimitis, the rules and regulations were breached. And I'm going to tell by step on this. The first one is the ASIC displayed its body evidence against Mr. and Mrs. Casimitis on the premise that they breached Section 180 by causing or potentially allowing Storm to give counsel to particular investors as per the Storm model. The next one is the ASIC claimed that the guidance given to those investors by Storm was unseemly to their own conditions, considering that each of the speculators were affirmed to be more than 50 years of age, were registered or drawing nearer and getting ready for retirement, had close to nothing or constrained salary, some assets, and had practically zero prospect of reconstructing their money-related position in case of suffering huge loss. Now, those were the duties and responsibilities that were breached in this case. The next one is why those that led to the breach of the contract. The reasons for breaching the contract was that Mr. and Mrs. Casimitis wanted to energize proposals, correspondence, or new thoughts. The control that they affirmed was brought to the point that it generously smoothed most probability of dispute or logical inconsistency. Apart from that, there were other more reasons for the breaching, such as getting against the security of their home loans, acquiring a credit, and utilizing the assets from these loans to put resources into index funds. Now, the further part, I'd like to call my friend Mr. Ahmed to tell you more about the critical analysis of this case. Thank you.
Hi, I'm Smith. So I'm going to discuss about critically analyze the case. However, the case has already been has been decided. I'm going to critically analyze the case in both director's point of view and court's point of view. The case on one hand discuss about the duties and responsibilities of the parties involved, and on the same time discuss about the breach of act. The parties involved are the directors and the low-income retired or near to retirement group who have few assets with them. The directors are the parties who are involved in the case. The directors had proper idea and knowledge about the model, and they have introduced. The model provoked the investors to invest in the securities against their home. Moreover, the court also found the reasonable director might have found that the low-income group might have been inappropriately advised to use their homes as security for the investment. The court decision was not solely based upon the financial loss. It was more focused on other non-financial and reputational harm which have been raised. The director's duty of care and diligence has been breached. The court therefore finds Storm Financial guilty of inappropriate financial advice provided to its client. Critically examining the case, there are other things which might have happened for downsizing of the share market and company collapse. The model used by Storm was not totally wrong. The model was just inappropriate to low-income class people, as it used to motivate people after their first investment, which they call as Stormified. The case further saw many people suffering significant loss by 2008 and 2009. Further, the case also discussed about Section 945A1 and Section 912A1 for the advice being inappropriate and breach of general obligation to comply with financial service law. It's the obligation of professional to provide reasonable solution to its client, not only by identifying the subject matter but also the circumstances of the client. Application of self-skill and knowledge is must for the purpose. The module and the idea of Storm of one size fits all have been filled on the basis that the entire client does not necessarily have the same circumstances as expected. Section 961B2 best interest safe harbor requirement regards client requirement as prime consideration in determining the advice on the subject matter. All the subject matter inquires and relevant issues must be addressed before making any suggestions. Casimitis argued that the solvent company's only interest is the interest of its shareholder. Furthermore, I am going to discuss about the reasons for court's decision. The court made the decision not only on the financial loss. The court concluded that the advisor should assess the circumstances of individual, the income group, rebuilding capacity, and assets before making any advices, because one size doesn't fit all. Had the precautionary measure been applied, it would be simpler to avoid the application of Storm model to this class of person. Further discussing about the relevance and impact of decision to the operation of companies in Australia, I'd like to invite Mr. Subhas. Subhas for the rest of the part.
Hi, good afternoon. I'm going to introduce about the relevance and the impact of the decision of operation of companies in Australia. Although this case is pre-decided by the Federal Court of Australia, I would like to put some light on this. The Federal Court established that directors of Strom Finance Limited, Strom, had breached their duties of care by triggering and authorizing the companies to contravene provision of the Corporate Act under Section 180A of Corporation Act. Directors and the officers' duty must exercise their power in discharge their duty with the degree of care and diligence that responsible person in their position would exercise. The recent case discussed the important principle about the stepping stone approach to liability and the duty of care. All directors should familiarize themselves with these principles, including the followings. I'm going to discuss about the directors, which they must familiar about the duties. Director who authorize or permitted of company contravention to do automatically breach their duty of care. Each is research on its own facts. The another one is, for the director to be found liable, the company need to have committed an actual breach of the law. The risks of the breach by the company may be sufficient. In Strom case, the Justice Illman doubt whether the actual breach by the company is necessary requirement for the breach of Section 180 by the directors. He said, suppose a director unnecessarily within the term of Section 180 and intentionally commits the act which is extremely likely to involve in serious breach of the Corporate Act. In determining whether the director duty of the care has been breached, the court will consider all the circumstances, including the foreseeable risks of harm to any of the interests of the company as well as the potential benefit to the company. Directors can breach their duty of care even if the directors are only shareholders and the company solvents. In this case remains as a legal guidelines for the future operation conducts regarding directors' rights, responsibilities and liabilities, which will save the activities of Australian corporate sector. Thus we can conclude that this case is a broader impact on the operation of the companies in Australia. Thank you so much for your attention. This is our group presentation. Thank you very much. We would like to